difference, knowledge, falsity, First Amendment. I think that's it. I think that is it. Oh, hi. You got here just in time. Welcome to Southern Law After Hours. I've been researching tonight the secrets of Amber's appeal, and I think I've found the answers. I'm going to share them with you. I've surveyed everything from the most unhinged tweets to state and federal statutory and constitutional law, case law, the judges' rulings, all the way up to the Constitution of the United States itself. Now, I've read a lot of what people have posted online, just like you have, but it might surprise you. The fact is that most legal precedent does not begin with OMG. It just doesn't. Instead, we have to look at dusty old books, or the internet, of course, to find out what the rules are in the court. What are the real grounds for appeal? Here, Elaine has laid a trail of breadcrumbs that tell us that telegraph to us what she's going to appeal on, what is her strongest argument. And that's what we're going to look at. It's essentially a point of wisdom that when you do appeal, there are limits to the length and things like that. You should limit how many things you complain about. You don't want to make it sound like the trial judge is completely bananas, because it's hard to get the appeal court to believe that. So you want to lead with your strongest argument and maybe a few more other than that, and that's what your appeal will be. We'll look at what they have telegraphed as their strongest argument. Let's see. Yes. My old tweet manual here from Elaine's team. We believe the court made errors. Okay, that's a clue for me at first. The court made errors. They are here not complaining about the jury. There's no mention of a juror 15 or unhinged social media or things like that. The court made errors that prevented a just and fair verdict consistent with the First Amendment. We are therefore appealing the verdict. Consistent with the First Amendment. What does the First Amendment have to do with this case? Anybody on Twitter who pretends they're a lawyer is going to tell you that defamatory speech is not protected by the First Amendment. But the judges and the people who make the laws are not on the internet making tweets. They're busy applying the actual real law. And that's what you're going to get a look at tonight on After Hours. So if you've watched any of the other videos about this topic, you know that the appeals court is not going to just completely redo a whole new trial. They're looking for essentially errors of law. It's going to be a 3-judge panel who's going to consider the briefed arguments of the parties, maybe a short oral argument, then they're going to issue a decision. Primarily what they're looking for is there a mistake of law that the judge made, the actual law applied was wrong, or the way it was applied was wrong or interpreted wrong, was something so egregious occurring in the courtroom that as a matter of law they're going to throw it out. That's usually what an appeals court is going to consider. And Amber Heard's attorneys are shooting straight at that. They're aiming here for something that they consider a case of first impression in Virginia that they think should go their way, that would create or clarify the law in Virginia. So a defamation claim is typically a state court claim. So all 50 states can have, within reason, their own little tweaks and theories about defamation and how they define it and how they apply it, how they have damages for it. But Amber's team is correct that the First Amendment sets some limitations on what a state can do in a defamation case, because the First Amendment protects speech. True, it doesn't protect ordinary sorts of defamatory libel and that sort of thing, but there are limits that might surprise you that are going to be the basis for her appeal. I mean, she says it right in her note. This is going to be about the First Amendment. So let's look at what that is. In a normal case in Virginia, the Virginia Supreme Court says that in a complaint for that, a lawsuit for defamation, you have to set out what are the defamatory statements? How do they refer to the plaintiff in the case? And if it's not obvious on the face of it, explain in your complaint how the statements would be taken by the reasonable person perceiving them to be defamatory. But in a case involving a public figure, the Supreme Court of the United States has added an additional burden to that. You have to show actual malice. So in a normal case for defamation, at least in Virginia and many other states as well, malice is not a necessary component of the claim. It can be for punitive damages, but it's not just for a defamation case. However, it is if you made a comment about a public figure. The court's reasoning is that if you make yourself into a public figure or you become one, then you become part of public discourse. And that becomes more protected under the First Amendment than just two people saying one person says something bad about the other. Once you're talking about a public figure, you're talking about somebody who is in the sphere of public discussion, and the First Amendment protections begin to apply more. So here they say you have to show malice, and you have to show it by clear and convincing evidence. So Johnny Depp was a public figure. He didn't contend that he wasn't. So was that a problem in this case? Because this is starting to bring in federal law, the First Amendment protections that Elaine is talking about, to protect her client Amber Heard. Was that a problem in this case? Now, that's not going to be what her appeal is, because the judge rightfully included an element in the jury instructions that the jury returned with for clear and convincing evidence that malice was present as Amber Heard made the statements that Johnny Depp said were defamatory. So the judge covered that aspect of what is required under the Constitution according to the Supreme Court. But this case was not a straightforward defamation case, and not even a straightforward defamation case about a public figure. Instead, the claims by Johnny Depp were called defamation by implication. In other words, if you just took what was said on its face value, it wouldn't necessarily be defamatory towards Johnny Depp. There was no statement by Amber Heard that was actionable in this case saying Johnny Depp abused me or Johnny Depp did this. Those were not the statements at issue. So in other words, it had to be by implication. You had to understand from what she said that she was referring to him and that the things she said were defamatory toward him. Now, the jury did find those things, but still it was by implication. And in defamation by implication against public figures, there is a split in courts as to whether and how those cases can go forward. In some jurisdictions, they kind of proceed like others, but in some jurisdictions, it's considered either not a cause of action or a cause of action is extremely disfavored. The theory being, if you publish something that is facially true about a public figure, we don't want people litigating over that. If people are allowed to say more things, expansive things, especially if they're look like they're true on the surface, we don't want lawsuits over that. It's just chill free speech. So there is sort of a split on that. And Elaine makes the argument, or she made an argument in the motions earlier, the post-trial motions, that this is a case of first impression in Virginia, that Virginia has not decided in a cause of action of defamation by implication involving a public figure whether facially true statements can be the basis for a cause of action. Or, she argues, if the judge won't do that, then the judge should have set up a test that the only way this case could go forward is if you took the facts alleged by Amber in her defamatory statements, put them together, and they were facts that this is true and this is true, but if you sync them together, they become misleading and defamatory. Or if she omitted material facts that Elaine wanted the court to either say you can't do it at all if it's facially true, or if you can, just under these limited circumstances. The judge, of course, denied that motion and let the verdict stand. So this is what Elaine is saying the First Amendment protects, that this begins to operate in this sphere of a heightened public discussion, that you shouldn't make these kind of lawsuits so easy to bring against people because it was chill public discussion. Now, she should be in the loony bin for this? Not really. There is case law that supports the argument she's making, and there is a federal case that covers the area of Virginia that is a little consistent with what she's talking about. So she has grounds to say what she's saying and to ask the court to make this law. I don't think it's going to be successful. I'll show you why. A big problem for Elaine in this case is the lack of precedent establishing her position in Virginia. If you watch my earlier video on why the Depp case isn't precedent where it is so far, you'll know the legal definition of that. But to hit it again, precedent is an opinion given by a court that is binding on courts below it and to itself as long as it follows along with that. So you would look to the Virginia Supreme Court and see if did they speak to this issue before? Have they laid down the rules for this? And they have not, and that's why she says it's a case of first impression. So she has to go searching for other states to support what she says, which is fine in the case of first impression because obviously there is no authority in Virginia on that, if she's correct. She also spends a lot of time talking about a Fourth Circuit Court of Appeals, which is a federal court of appeals, higher than the district court, saying that in a defamation by implication case, that they find that a plaintiff in that case has to make an especially rigorous showing and adopt that standard. And Elaine certainly wants that to apply here. The problem is that the Fourth Circuit Court of Appeals, while it is a high court, it's just below the United States Supreme Court as far as the federal level goes. It controls the district courts of several states, including those in Virginia. the Fourth Circuit Court of Appeals does not control the state courts of Virginia. In fact, in a defamation case, they're supposed to apply the law of the courts of Virginia. They're supposed to apply the Virginia court's law, not the other way around. The only substitute to that is if they start violating federal law. But if you want to go from the Virginia Supreme Court because of that, you need to go to the United States Supreme Court. It doesn't go to the Fourth Circuit Court of Appeals. So that the Fourth Circuit Court of Appeals can be instructive in terms of their logic, but it isn't binding on a Virginia court. And in fact, the Virginia Supreme Court had something to say about it in a case called Pendleton v. Newsom, which had to be argued by Elaine because it is authority on this matter from the Virginia Supreme Court, so it would apply. And it was also brought up by Depp's team because it's a case that they want the philosophy of it to control what is going on here, even though it isn't directly precedent for what is happening. Let's see what the court has already said on this issue. The court also goes on to note the defendants in that case say their statements were protected by the First Amendment, but the Supreme Court of Virginia says defamatory innuendo is no more protected by the First Amendment than is defamatory speech expressed by other means. They note the Fourth Circuit's ruling that says a libel by implication plaintiff must make an especially rigorous showing. However, then the Supreme Court of Virginia goes on to dunk on the Fourth Circuit Court of Appeals, saying our decisions in defamation cases do not include a requirement that a libel by implication plaintiff must make an especially rigorous showing, where the expressed facts are literally true. The plaintiff's burden is proof by a preponderance of the evidence. So the concept generally that a defamation by implication case would have to have this higher burden has been rejected by the Virginia Supreme Court. And they talk in the case, as some other cases similar to theirs do, that we don't want to create a situation where the clever person can defame people simply by implying it, an innuendo, that as long as you can write it in a crafty manner, you can slander and libel somebody to your heart's content, you don't have to answer for it. They reject that, and they say, no, we're not going to do that. We're not going to put this as a special burden on you. So there is already an extra burden if the person is a public figure in that they have to show malice by clear and convincing evidence. But there's no Virginia authority that says that just because it's implication, it has to come up with some new heightened standard. So it seems unlikely that Elaine will be successful in having the Virginia Supreme Court, and she's not there yet. She would only be at the Court of Appeals, having the Court of Appeals announce a new doctrine that puts this burden on plaintiffs to get a judgment of defamation by implication against somebody, even in a situation where the plaintiff is a public figure. The case doesn't control because the plaintiff in this case was not a public figure, so that element was not present. However, it suggests to me the opposite of what Elaine says it suggests. She says it supports her position that the court wants to be tight on this kind of case. I think they threw that out and said, we're not doing that. We're not going to open the floodgates and let people just cleverly write things, have lawyers go over it, and as long as you word it right, you can still get your meaning across and tear somebody up and destroy their reputation, and we won't let them come to court because not what you said, but just how you said it gets you off the hook. They didn't find that argument persuasive before. Now, it goes up to a panel of the Court of Appeals, and it's all going to depend. But since this is a matter of law, the law is not looking good for her on this appeal. But it's a novel argument. It's a fair argument. And I think it's going to be the primary argument that she's going to have on appeal. There's one more weakness in this, which Elaine keeps talking about facially true. And she says, at least she did say in her brief to the court at the trial level, that Depp's team did not contest the facially true statements. And I do not buy that argument at all. From the very start of the complaint all the way through the closing argument, they always contested all of it that about the abuse. That they said he didn't abuse her. What Depp's team says the implication was the identity of the abuser, because her didn't hide the ball in her statements that she was accusing someone directly of abuse. They say that what was implied there was anybody reading that obviously would know she is saying that she was physically, sexually abused by Johnny Depp. And that's how everyone took it. Everybody from the circumstances of the thing knew that's what she meant. She knew it was what she meant. Everyone else knew it was what she meant. So I see Depp's team's argument as stronger there, that they did contest the things they needed to contest. And I don't see Elaine's point as being successful there. However, Depp's team dunks on that in their brief at the trial level, saying that even if you adopted Elaine's standard of that you had to show omission of material facts to proceed with this claim, they did that by showing that Amber Heard omitted the fact that she wasn't abused by Johnny Depp when she made those statements. So that's no need to put that in there except as a massive dunk, but it is one. But it'll certainly come back up on the Court of Appeals because the jury supported that interpretation of what they're saying. So here we see that based on Elaine's statements to the press and prior filings, we kind of see what is likely to be her primary argument in the appeal. It's not frivolous. I know people want to think that it is. I don't think it is. It is a case of first impression. The Court of Appeals could clarify the law on this. They could change the law on it. Consequently, it could, hypothetically, end up in the Virginia Supreme Court even after the appeals court decides. And she may make other arguments. I would not be surprised if there's an argument in her assignments of error that the jury verdict is wrong. The amount is wrong, that wasn't protected by evidence or something. It's unlikely she'll make a single issue argument on appeal. But I don't think she's going to throw 12 things at it either. So this First Amendment thing should be front and center because it is a point of law that some jurisdictions disagree with. It's not fundamentally decided in Virginia yet. It's just kind of suggested that by the court's rulings. So that's a good one. And the rest of it we'll just have to see probably on damages, maybe one other thing. I don't think there'll be a whole lot of things. I don't think she's going to win this appeal because of the way the law is, the way we've discussed it already. You never know. We'll just have to see. But you know better than most people now on the internet of what is really going on behind the scenes here, what's happening. There's no OMG or LOL in this. It's a real legal issue. I think it's still probably a loser. We'll see how it turns out. Thanks.